Judge, hi. During our courtesy visit, I asked you if you'd read the New York Times investigative series on the pervasive use of forced arbitration. You hadn't, but you said you would. Were you able to do so?
I was. I managed to fit it in, Senator.
Thank you. Thank you so much.
No.
I said, you don't have to read this. And you said, no, I will. I promise. And you did. So thank you. I don't think that most Americans realize that when they sign up for a credit card or cable service or sign an employment agreement or fill out their parents' nursing home resident agreement, that they're also signing away their constitutional right to go to court. The New York Times series, while shocking, illustrated something that I have been saying for quite a long time. Forced arbitration clauses, which are buried in the fine print of contracts that we sign every day, restrict Americans' access to justice by stripping consumers and workers of their legal rights and insulating corporations from accountability. Businesses across the nation use these clauses to force individuals into a privatized justice system where the corporation can write the rules, everything can be done in secret without public rulings, discovery can be limited, making it hard for consumers to get the evidence they need to prove their case, and there's no meaningful judicial review, so there's not much a consumer or employee can do if the arbitrator gets it wrong. It's simply unfair. Now, there seems to be no question about how arbitration clauses came to permeate nearly every aspect of our lives. In a series of decisions, including Rent-A-Center, Concepcion, and Italian Colors, the Roberts Court effectively reshaped the Federal Arbitration Act into a permission slip for corporations to opt out of the civil justice system. And in the years since, we've seen business after business use arbitration clauses to avoid accountability for their wrongdoing under even the most egregious of circumstances. A few years ago, my staff heard the story of a 71-year-old man at a nursing home who died from, quote, profound dehydration, and whose family was forced into arbitration to resolve their wrongful death claim. Last year, we learned that Wells Fargo customers who had had fraudulent accounts opened in their name and without their consent were forced into arbitration because the bank successfully argued that the clause in their real accounts also applied to their fake accounts. Very recently, Fox News tried to force its former anchor, Gretchen Carlson, into arbitration when she sued her boss, Roger Ailes, for sexual harassment. Fox News also tried to use the arbitration clause in her employment contract to prevent her and other victims of his abuse from speaking to anyone about what had happened to them. Companies have also learned to pair forced arbitration agreements with class action bans to shutter the courtroom doors to groups of individuals with small claims. And once blocked from going to court as a class, most people drop their claims because it doesn't make financial sense to go it alone. Now, this way of doing business is profoundly unfair and unjust. It is anathema to our system of civil justice, and it doesn't even scratch the surface of the many stories that the New York Times series revealed. Judge Gorsuch, what was your reaction to the series? Were you shocked? Because I've worked on this issue for 8 years now, and even I was shocked.
Senator, it made me think about a little bit of history. It used to be back at common law that arbitration was disfavored because it was thought that everyone should go to trial. Trials were the norm, Seventh Amendment and all that. And then in about, I think in 1925, Congress passed a law
24.
called the Federal Arbitration Act.
24.
24, okay, all right.
Very, very close.
All right.
As close as you can get without being right.
I try.
Yeah, it's very good, very good.
And it made me think of that. It made me think, well, gosh, it doesn't have to be this way. The Federal Arbitration Act, what it did was to favor arbitration. Congress expressed a preference that people should arbitrate their disputes. It made a judgment, policy judgment, in favor of arbitration because it's quicker, cheaper, easier for people.
But that was really conceived in 1924 as two equal parties, business to business.
Yeah.
And what I'm gonna continue on here, because I mean, unless you want to.
Well, I wasn't quite finished, but if you, it's your time.
Finish.
I don't.
It is my time, but if you can do it short, why don't you finish your
I'll do the best I can.
Okay, thanks.
If Congress thinks that the courts are not applying the Federal Arbitration Act as it wishes, or if it wishes to revise or eliminate the Federal Arbitration Act, I mean, 1924 is a long time ago. And
well, my feeling is that the court, through these 5-4 decisions, the Roberts Court, has changed what the intention of the law was back in 1924. But I'm going to continue. In our courtesy visit, you emphasized the threshold question that you say the Federal Arbitration Act requires. In the opinion you authored in Howard versus Federal Gas, you discuss how, when dealing with arbitration clauses, courts must first determine whether an agreement to arbitrate between two parties actually exists, and you go on to detail the analysis of the contract formation principles that must happen in order to make that determination. I think I understand what's required in that threshold question, but in order to fully grasp how you will approach the issue of forced arbitration going forward, I want to move on to the next step in the analysis. So assuming the parties did in fact form a contract, I want to know whether there are any circumstances under which you believe that the mandatory arbitration clause should not be enforced. In other words, let's talk about the practical outcomes that arise when courts enforce these clauses, and whether, in your view, any of them make clauses so unfair that you would deem them unenforceable. I'll give you an example of how forced arbitration affected a Minnesota soldier who was deployed at Camp Anaconda in Iraq. Now, I know Camp Anaconda. I visited 4 times on USO tours. I'd go there, I'd tell a few jokes, and then leave very quickly. See, Camp Anaconda has a nickname. The soldiers there called it Mortaritaville because it was hit so often by enemy fire. And in fact, the first soldier I ever met in Walter Reed had lost both of his legs to a mortar at Camp Anaconda. Well, one soldier who was deployed at Anaconda, Minnesota soldier, learned while he was there that his house had been foreclosed upon and sold in clear violation of a law we wrote, Congress wrote, the Service Members Civil Relief Act, which protects service members from civil actions while on active duty. The mortgage lender had falsified paperwork stating under oath that the soldier was not in military service. So the house went into foreclosure and was sold at an auction for 1/3 of its assessed value. Can you guess who bought it? You can't, right?
I can. You've shared this with me before, so I actually know who bought it.
Oh, okay. Well, then
that's okay.
Fair. The bank.
The bank, right.
The bank.
Right.
It turns out there were over 80 other foreclosures that had taken place against service members by the same lender. So the soldier tried to file a class action suit on behalf of his fellow service members. Unfortunately, a mandatory arbitration clause, which the soldier didn't even realize was buried in his mortgage documents, also included a ban on class action suits. So his case was not only forced out of court and into arbitration, but he had to go alone. Now, fortunately, the Minnesota soldier had a lawyer willing to take on his individual claim, even though that's not cost effective for the lawyer. They eventually settled on terms that are confidential. As a result, we have no real way of knowing how many other service members' rights were violated. or whether this particular service member was ultimately made whole, and of course he was prevented from even telling the other 80 service members who had been harmed how it all went down. Judge Gorsuch, this is a case where we know the law was violated. We know that a bank unlawfully took this soldier's home while he was away serving our country. And to add insult to injury, the man also lost his constitutional right to have his claim heard in a public court of law. So tell me, was it fair to limit this soldier's claim to secret arbitration and to prevent all the soldiers who had also lost their homes from being included in this case?
Senator, I'm a big believer in jury trials and in the Seventh Amendment. And in the Rules Committee over the last 6 years, I've worked with my colleagues to try and make litigation cheaper, faster, and more accessible so that people can vindicate their jury trial rights. Got a proposal with a wonderful judge from the Ninth Circuit, currently pending before the Rules Committee, asking if we can actually reverse the presumption. Because right now, when you file a complaint in federal court, if you don't specify that you want your jury trial right, it goes away. And you're presumed to want a bench trial. I don't understand that presumption. I think it should be the other way around.
I'm talking about in these agreements, on this particular agreement. This is settled. This case is settled. This is not a live controversy. The thrust of my question is, when do the principles of equity and fairness apply? So once there is a determination that there is indeed a contract, what does it take for the courts to decide that the outcome is so unjust that it cannot be enforced?
Well, under the Federal Arbitration Act, which is an act of this Congress, an act of lawmaking by this Congress, the first step and the key step is, did the parties agree to arbitrate? And normal state contract formation principles apply there.
I know. We talked about that. That's the initial test.
I think it's very important, though, Senator. If you're asking me the question, I have to give you the answer. And the answer is, under normal state contract formation principles, there are a number of defenses that can be raised. Unconscionability might be an argument, if I were a lawyer in this case, that I'd want to raise in the case you're presenting. That would be an argument I would raise.
Don't you think this was unconscionable?
That would be an argument, if I were a lawyer, I would want to raise. I don't know how I'd come out. I'd have to have the full judicial process in order to adjudicate it, but that would be an argument. If I were the lawyer, that's one I would make. Right? I'd also, if I were a lawyer and worried about these things, come to this body and ask you to revisit a nearly 100-year-old law and perhaps rethink the balance between arbitration and jury trials.
Well, I've done that with my Fairness and Arbitration Act, which I keep introducing. Let's turn to the secretive nature of forced arbitration. Last year, the public was shocked to learn that over the course of 5 years, Wells Fargo employees have been incentivized to open millions of sham accounts in the names of Wells Fargo customers and then charge the customers for those accounts, of course, without their permission. Many of them lost their credit rating, just plummeted. This was a bad outcome for these people. One reason this fraudulent practice was allowed to continue for so long was because Wells Fargo's customer account agreement included and continues to include a forced arbitration clause. When customers discovered and attempted to sue Wells Fargo for the sham accounts, the company argued successfully that any dispute arising from the sham account was covered by the arbitration clause in the real account. So those customers were forced into secret arbitration. One such complaint was filed in September of 2013. If that suit had been able to proceed in court, other Wells Fargo customers could have been alerted to the wrongdoing and may have been able to save themselves from being charged for the sham accounts. And the life-changing damage it did to their credit scores, to their bank accounts, to the ability to buy a house. Judge Gorsuch, would you agree that one benefit of our civil justice system is ensuring that other victims are made aware of widespread wrongdoing and that such awareness allows them to mitigate the harm for themselves?
I've spoken about that very issue, Senator.
Good. Now, it doesn't just hurt customers. It hurts employees. 2 weeks ago, I, along with a few of my colleagues here, introduced a number of bills aimed at combating unfair forced arbitration clauses. In advocating for our legislation, we were joined by former Fox News anchor Gretchen Carlson. Last summer, Ms. Carlson took on one of the most powerful men in media, Roger Ailes, suing him for sexual harassment. Mr. Ailes' lawyers tried to force her case into private arbitration because of an arbitration clause in her employment contract. Even worse, the arbitration clause also prohibited her from speaking out about the claims, as is the case in most employment arbitration agreements. Had Ms. Carlson chosen to sue Fox instead of directly suing Mr. Ailes, her colleagues at Fox News, many of whom were also victims of sexual harassment, would have been left in the dark about her case and may never have come forward with their own claims. And Roger Ailes' now well-documented abuse of women might well have continued. In an op-ed published shortly after she joined us on Capitol Hill to talk about her legislation, our legislation, the group of senators who met, Ms. Carlson wrote, quote, "So many women are being silenced by employers who force them into a secret star chamber proceeding called arbitration. By coercing women to remain silent about illegal behavior, the employer is able to shield abusers from true accountability and leave them in place to harass again," end quote. Judge Gorsuch, the Seventh Amendment gives us the right to a trial by jury in civil lawsuits. Would you agree that a critical aspect of a jury trial is the fact that it is usually open to the public?
Absolutely. The Seventh Amendment, I'm a big believer in the Seventh Amendment, all the amendments. And that amendment, civil jury trial, I've spoken about this a lot over the last couple of days. I believe in it. I believe in juries. I believe in the civic involvement of the people in their government. I believe in the openness and transparency of a courtroom, the ability of every person to come into it, poor or rich, mighty or meek, and have their cause heard. There are so many virtues to it. Transparency is one of them, absolutely.
I'm so glad to hear you say that, because these decisions, one 5-4 decision after another by the Roberts Court, has closed the jury to employees, and to customers, one after another. And that's why, frankly, there's so much at stake here. As Senator Whitehouse has demonstrated, what we're worried about is another 5-4 Roberts Court making one decision after another that hurts workers, employees, that hurts consumers. And, you know, you said earlier there's no Democratic judges, there are no Republican judges. If that's the case, what was Merrick Garland about? That's what it was about. It was about, let's leave this up to the election, even though there was almost a year left. That's what this is about. And what this court has done, and listen, I'm sure there are a lot of cases decided where judges go back and forth, but there's a sort of core group of cases in which the Roberts Court continually has ruled in favor of corporations, and against workers and consumers. That's what this is about. And that's why this isn't, sometimes, I know I'm over my time, Mr. Chairman, and I'll just try to finish out with a thought.
Okay, go ahead.
I think I have a thought. Maybe. Thank you,
Okay.
ranking member. This is really about something. And my colleagues on the other side say, you know, that we're making something up over here. We're trying to really figure out whether we're going to see a continuation of this pro-corporate bias and of this bias toward big money and a perversion of our political system like through Citizens United, and where the weight shifts against the little guy and for the big guy. And if this election was supposed to be about the little guy, but that's my thought.
Can I, Giselle, Senator Franken, if you want another minute, you can have a minute of mine.
I want to move on.
Okay. Chairman.
Wait a minute. He gave me a minute. Ah, gee.
I want to be, when he gets done, we're going to take a 10-minute break
Thank you.
for the benefit of the nominee.
Thank you.